digital law is just another thing that the rights dissembles are to commercial law in the civil criminal Business Center, among other translate spreads in the digital field between what is the right digital law is born as a result of what is the economic and that the digital business. The importance of technologies nowadays in full globalization of digital media invades our daily life so much so that digital tools and devices are part of our routines and needs. In the professional field, the application of technology has been fundamental not only to generate better results but to expand knowledge of the field at an international level and thus be
The
able.
conceptual of digital justice in Colombia. We start this chapter explaining the importance of the creation of 1991 Constitution because it was intended not to allow again the fatal historical repetition of continuous and direct violation of fundamental rights, so that the implementation of digital justice that respond to the new ways of with the country was direct. It was a great deal of the time when it offered hope in more agile, almost personalized justice and easy form legal formalities, all into the common knowledge of the people. With the idea of mind, the statutory law on the administration of justice was promulgated in 1996, Law 270 of the year in question, and was intended to guarantee every Colombian citizens the way in inspection of technology evolution. And it took 15 years since Law 1437 of 2011 that the promise of digital justice administration create some factors, for example, the judicial file, the hearing and procedure in electronically, the electronic notification, and online litigation. And then with the conclusion regarding on the conceptualization of the concept of digital justice, it can be said that it had great adaptation through the very creation of the concept. Since the 1991 Constitution, the values and importance of adaptation to the new ways of seeing and understanding the administration of justice, it develops have been promoted being either implementation and almost a legal community. It is evident that even these days there are gaps that do not allow its perfect functionality, but it's necessary to those who know the hero of law to be able to materialize digital justice, guarantee it access to all without any distinction. And almost the most important thing that I took tackle efficiency in general in generate a running node passion in terms of application.
In the third chapter, we may highlight the material application of digital justice in Colombia. How Law 527 of the 1999 in the General Code of the Process acquired an important relevance during the sanitary affectation that welcomes as of the moment worldwide. This affectation was the main reason for the Colombian justice to initiate the transition to provide an essential public service such as the administration of justice digitally. For many people to access this public service throughout the national territory. As a conclusion for this chapter, we have that for effective application of digital justice in Colombia, access to the internet must be guaranteed as fundamental right, so that this policy is inclusive of all people, including those who do not have access to technological tools.
In Colombia, we present a problem regarding digital use. In this due to the fact not the institutional accept the modality of virtual demand by the Superior Council of the Jurists. In 2012, with make reference, we are talking about institutions such as the judicial branch. Since it was one of the most important about the virtuality. On the contract, what superintendents and another institution did. Article 95 of the Statutory Law 217 of the 1996 term from the use in Colombia gives a Superior Council of the Judicial and responsibility in corporate technology development in key aspect the system operation. However, the current health situation has revealed the country limited progress in this file. Now, why with Center 34 of Decrease 806 of 2020, the emergency that country is experiencing that the COVID-19. Indeed, can be said virtually was born graduate access of the use, but the problem with this canon graduate precedent security in development and the judicial process. Since virtuality is completely dependent in the internet and energy, causing difficulty of the official and other parts who work with the process. With practice, speaking from experience that I have in the face the presidential virtuality handled by Decree 86 of the 2020, I can affirm in the inexplicability development public official and judicial office of the decrees because they don't completely according with the provision of decrees. A clear example of this non-court are sending or suites of 80-2020 give office obligation
instrument for communication and information for the people, allow and facilitate the exercise of the freedom in these various manifestations by time that must be government and their access and their operation by the principle. Regarding equality, its relevant respect with the new technology is already important since these values should govern access and use the new technologies in the same way, not only because the prohibition of discrimination against uncertain group of access, but also because of the duty and the public power make this equality in access effective. As conclusion, we can affirm that the use of the technology and this proper application in law can generate benefits for all the parties included in the process. Colombia must look at the international level that it can implement in its own system in order to create an environment of legal security for the community and all the people in here in Colombia that attend it day by day. Human dignity must be highlighted among the constitutional principles, which must be applied in all science and technology, and which in no cases is violated. In the same way, the principles of freedom, equality, and political pluralism are applied in this matter. The first one of that encompasses the free development of this personality which plays a fundamental role since new technology, as they are suitable instruments for communication and information for the people, allow and facilitate the exercise of the freedom in these various manifestations by time that must be government and their access and their operation by the principle. Regarding equality, its relevant respect with the new technology is already important since these values should govern access and use the new technologies in the same way, not only because the prohibition of discrimination against uncertain route of access, but also because of the jury and the public power make this equality in access effective. As conclusion, we can affirm that the use of the technology and is disproper